Welcome to SQE1 window with chapter 5, and our focus is on directors. Now, directors are the folks running the show in a company. They supervise management, make strategic calls, decisions and everything. But don't forget, the shareholders still hold the ultimate power with their special resolution under Article 4, subsection 1. Think of it like the board are the pilots, but the shareholders hold the parachute. We have several types of directors: executive director, non-executive directors, de facto directors, basically anyone acting like a director without the official badge is a de facto director, and shadow directors who are pulling the strings from behind the curtain. Yes, even a puppet master can be a director in the eyes of law. So what are the minimum requirements to become a director if you want to become one day? Now, say private companies need at least one director. You need almost £14 to become a director in this country. Public companies need at least two, and at least one must be a human. Like it can be one human, another company, not a robot. Like thanks to section 155, you must be 16 or older, and certain people are disqualified, like undischarged bankrupts or those with debt restriction. So if you were hoping to become a director while hiding from your creditors, the law has other side, won't allow you to become a director. So the next thing to understand is register of directors. Every company must keep it. So every company must maintain a register of director with name, address, and date of birth. This is publicly accessible. So no hiding behind a fake identity. Private companies can sometimes skip a physical register if they notify Company House, but you still have to update the online record within 14 days of any change. Only the address of service is public, so director can still keep their home address secret because privacy matters, even in corporate land. Yeah. So how to appoint them? Directors are appointed either by the members or the board. The first director are named at incorporation. Removal, like you can remove them by ordinary resolution within 28 days, like special notice. Like you need to give them notice before removing them, otherwise they will take you to the court. Directors can be removed if shareholders lose confidence in them, unless there is Bushel versus Faith clause. That's where a director shareholder can use weighted voting to block their own removal. Clever, but potentially messy for governance. So, what is their remuneration? Once again, I mentioned earlier as well. Yesterday, Tesla board approved $1 trillion salary for Elon Musk. So directors usually decide their own pay, subject to articles if it is there. Non-executive or company or committee often check this to prevent cheeky self-enrichment. Service contracts set out salary, benefits, duties, and termination rules. Guaranteed employment are over 2 years, for example. If it is like 2 years or more employment, members must approve. So it will not be board; it will be members who will approve it. And member keep a copy of expired contract for at least 1 year, just in case someone wants to reminiscence or investigate what was in their contract. So power and authority of directors power are derived from article, and the model articles give board management authority. Decisions are usually majority vote at meeting or unanimous if agreed differently. Companies are bound by directors' actions through actual authority, which can be expressed or implied, and apparent authority, which is about appearance. Appearance is from appearance. Section 39 and 40 protect third parties acting in good faith. So if a director looks like they have authority, company may be bound unless someone is being sneaky at that point. So what happens in the board meeting? Board meetings must have notice to all director and maybe in person or remote. Video calls are fine on Zoom, Meet, Google Meet and all of it. Quorum is usually 2 directors and the CMs are by majority, with chair having a casting vote in case of tie, and that is from Model Articles of Association. You can change them as well. Record every decision for 10 years because, as in life, if it is not written down, it didn't happen. So the next thing is these clauses, you don't need to memorize these sections, but just for our LLB folks as well. So under section 171, director of 7 key duties. So promote company success under section 172, exercise independent judgment, section 173, act with reasonable care, skill and diligence, section 174, avoid conflicts under section 175, not accept third party benefits and declare interest in proposed transactions. They need to do it. These duties keep director honest and focused on company, not their own beach holidays. So yeah. So breach of duty and ratification and court relief, like once they breach it. Breach of duty are actionable by the company. Think damages, restitution, or an account of profit they have made. Members can ratify breaches, but fraud? No. Unratifiable fraud cannot be ratified. Section 1157 allows court to relieve director who acted honestly and reasonably, even some damage or some loss happened. Section 232 ensures companies cannot exempt directors from liability, though insurance and indemnities are allowed, so directors don't think you are just shrug off responsibility. It's serious business. It's not a joke. So the next thing is interest, property transactions and loans. Director must declare interest in, if they are interested in contract under section 182, substantial property transaction over 10% of asset value or more, or 100,000 or more. Need shareholder approval, so it will not go to board, it will go to shareholder. If it is substantial property transaction, it will be tested. It may be tested in your SQE exam. Loan to director generally need approval under section 197, except for small amount or ordinary course lending. These rules prevent directors from turning the company into their personal piggy bank. So, liability of directors. Directors can be personally liable through personal guarantee that they have given, negligent misrepresentation they have made, misfeasance, fraudulent trading, and wrongful trading. Fraudulent trading is particularly important if insolvency is inevitable. Directors must take steps to minimize creditors' loss. They should not go for shareholders. They should protect creditors more. Ignoring this could land you personally paying for company blunders. Not fun. Trust me, do it and pay it. Disqualification. Director can be disqualified for 2 to 15 years for misconduct, foreign offences, insolvency-related unfitness, or acting as puppet masters. Acting while disqualified is a criminal offence and you could be personally liable for company debt. So don't even think about it. Court take it seriously once you are a director. Common tips and pitfall. Type of director: executive, non-executive, de facto, and shadow. Keep in mind who are they. Minimum requirement: age, disqualification, and registers. Appointment and removal, including Bushell versus Faith clause, where removal got higher standards. Statutory duties 171 to 177. You got a slide on it. Go back to it and just read it through. Power and authority, there is actual versus apparent under section 39 and 40 of Company Act 2006. Substantial property transaction and loans, and there is approval threshold we need to look at. And pitfalls are confusing duties, ignoring procedural protection, misapplying authority, or forgetting disclosure obligations. And remember, directors have both power and responsibility. Mix them up, and it's a long night at company house if you don't like. Thank you very much. I hope it works, it makes your concept clear. If it is not, go back to this video, watch it or hear it again. At that point, it will make things more clearer, or I point you to our notes and question bank. Thank you. Ta-da.